Hi, my name is Steve Burton. I'm one of the lead criminal defense attorneys at Intermountain Legal. Today, I want to go through the criminal court process in Utah so you can better understand exactly what to expect. I'm going to talk about some of the possibilities that can happen and what some of your options are at each stage of the process. So, every criminal case in Utah starts with some sort of investigation. The investigation can be formal or informal. It's usually done by a police officer. If it's a less significant case, then it's done by a patrol officer, somebody who's simply showing up at the scene and asking questions. If it's a more serious case, that case can be passed to a detective, and the detective will investigate further and can initiate a formal investigation to look into the facts of the case. Once that investigation has been completed, or while it's being completed, the case will be screened for charges. And again, this can be a formal process or it can be a less formal process that's just done on the street right there while the officer's there. So if, for example, there's a report of a fight and there's not any serious injuries, and a police officer shows up and does an investigation, he may screen the charges right there and determine that he needs to give somebody a citation for assault or disorderly conduct. That's an informal screening of charges. In contrast to an informal screening, somebody can screen the charges formally. This usually happens by having the police officer submit his police report to the prosecutor's office. And then the prosecutor goes through the report and all of the evidence and decides what charges to bring against the defendant in that case, or against the suspect in that case. Once the case is screened for charges, then it will either be a misdemeanor, a felony, or an infraction, or nothing. The prosecutor can say, look, we don't feel like any charges should be filed, and so we're not going to file anything. If the case is a misdemeanor or an infraction, a Class B or C misdemeanor or an infraction, then it goes to the justice court, which is the lowest court in Utah. So this is for Class B and C and infractions. Now, if a case gets sent to the justice court, the first hearing that there will be is an arraignment. This is different than if the case gets sent to the district court. If a case gets sent to the district court, it's because it's a felony or a Class A misdemeanor. So if they screen the charges and decide, hey, this is a felony or this is a Class A misdemeanor, felony or a Class A misdemeanor, then it will go to the district court. And there's different processes that these will go through. If it goes to the district court as a felony or a Class A misdemeanor, the first hearing is an initial appearance. An initial appearance is mostly a formality. It's where they inform you of the charges against you. Now, they will provide you with something called a criminal information. It's actually a document called an information. And it will say the statute that you're being charged with and what the charges are against you. Also, at the initial appearance, they will decide if they need to post a bail on you, if they haven't already. And they will decide if there have to be any other pretrial orders put in place, like a no-contact order, to order you not to have contact with a victim, for example. After the initial appearance, they will schedule you for your next court date, which is usually called a scheduling conference. Now, a scheduling conference, different courts call it different things. Some courts call it a waiver hearing or a decision to prelim. Also, the courts used to call it a roll call hearing. The purpose of the scheduling conference is for the defense and the prosecution to meet together to decide if there's a possible resolution to the case. If there is a possible resolution to the case, then the prosecutor and the defense attorney will decide what steps to take next. Either they will try to resolve it right there during that scheduling conference, or they will decide what the next hearing is that they need to schedule, and then they'll meet with the judge to schedule the next hearing. After the scheduling conference, if the case cannot be resolved, then it will be set for something called a preliminary hearing. Now, a preliminary hearing is kind of like a mini trial. It's not as formal as a full-blown trial, but it is where the prosecution will present their evidence to the judge to show him that they have enough evidence to go all the way to trial. Now, this can be a very long process, especially if it's a felony. So because we don't want to drag people through this long process if they really haven't done anything wrong, in felony cases, that's why they have the preliminary hearing. So if they really don't have enough evidence against somebody, the judge will dismiss it and not continue the case towards trial. So the preliminary hearing is the judge's chance to see the evidence and for the defendant's chance to see the evidence to see how strong the case is against them. Now, most cases in Utah that are filed will go forward after preliminary hearing. So the judge will almost always say, yeah, we think that there is enough evidence that it can continue forward. So the next step in the process, if the judge says that, is something called an arraignment. And this is where the two processes meet up. So at this point, whether you're in district court or justice court, the process is somewhat similar. As you can see, for Class B and C misdemeanors and infractions, the justice court process is much shorter than the district court process. So if your case was a felony and you had your preliminary hearing or you waived your preliminary hearing, then the next thing is an arraignment. Or if your case was filed in justice court, then your first hearing is called an arraignment. An arraignment, it is again kind of a formality in the process. An arraignment is the time where you have to enter your plea. So this is where you say guilty or not guilty or no contest. Now, a lot of people think that this is the time where they can explain their case to the judge, and it's not. It's a time to enter your plea. And we always recommend that somebody pleads not guilty. There are very few situations where somebody should plead guilty at arraignment, and usually that's only because they can get you with more serious charges than what they actually charged you for. Then you may want to plead guilty at arraignment. Otherwise, 99% of the time, you want to plead not guilty at arraignment so that you can continue to negotiate your case and try to get a resolution that's best for you. So the arraignment, they ask for your plea. You should plead not guilty, and then they will schedule you for a pretrial conference. Now, pretrial conference is very similar to a scheduling conference. It's another opportunity, or for justice court cases, it's the first opportunity to try to negotiate the case, to see if you can reach an agreement with the other side. If you think that the case should be dismissed and they think the case should be dismissed, this is where you talk about it. Or if you think you can come to some kind of agreement to reduce the charges, this is where you talk about it. Now, sometimes there's one pretrial conference, sometimes there's multiple pretrial conferences, depending on how complicated the case is and whether additional information needs to be learned. If you cannot resolve the case at a pretrial conference, then the case moves forward. It moves to pretrial motions. Now, pretrial motions are basically things that need to be resolved with the judge before you go to trial. So if there's evidence that you don't think should be allowed to come in because you think it was obtained illegally, you can file a pretrial motion to say, Judge, we don't think this should come in. And that's all done before the trial, or it's usually done before the trial in pretrial motions. There can be one or there can be multiple motions that can be resolved before going to trial. Now, if through this whole process you're still not able to resolve the case, then sooner or later the decision that you have to make is to to go ahead and enter a plea bargain by pleading guilty either to the original charges or some kind of reduced charge, or by going to trial if they haven't agreed to dismiss the case. So all of this process is all going towards the final result, which is a trial or a resolution, a plea bargain or a dismissal. So if you haven't been able to resolve it, and you go down and you do a trial, that's what you usually see on TV. That's where you go into court and you have either a judge or a jury decide whether or not you're guilty on the charges. And you have an opportunity to present your case, they have an opportunity to present their case, and the judge or the jury decides what happens to you. If you don't do a trial and you decide to take a plea bargain, where you say, okay, I agree to plead guilty in exchange for a reduced sentence, or if I can keep it off of my record, I will go ahead and admit to it, or plead no contest, something like that. If one of these things happens, then the next stage is sentencing. So if you're found guilty, or if you plead guilty or no contest, then you will go towards sentencing. Sentencing is where the judge tells you what the punishment is, or orders you to do certain things based upon your conviction or your guilty plea. Sentencing can involve everything from jail time and probation to fines or classes or restitution or community service, among other things. The judge can give you what he decides is the penalty. Now, as I said, one of the possible resolutions of sentencing is jail or prison if it's a felony. Another possible resolution is probation. Sometimes in minor cases or where the judge thinks it's appropriate, they can also issue no probation. Most of the time it's one of these two. It's either jail or probation. Sometimes if it's a first-time offense and the judge doesn't feel like jail is appropriate, what they'll do is they'll put you on probation and order other things like paying a fine, community service, classes, sometimes drug treatment or alcohol treatment. And if you do those things, then you won't have to go to jail. Whereas if you don't do those things, then you have jail hanging over your head as part of your probation. That pretty much covers the whole process of a criminal case in Utah. The thing you have to understand is at any point in this process, you can resolve the case. If you can show the prosecutor that the case should be dismissed and they agree, you can dismiss this right up here, right when they're screening charges, you can dismiss it after you meet with them at a scheduling conference or a pretrial conference, or even all the way up until trial, they can dismiss the case. Or if you decide that you can reach a resolution with the other side, then you can enter a plea bargain at any stage along this process. If you'd like some help navigating this court process and finding out what the best strategy is to negotiate your case, please give us a call at Intermountain Legal. Again, my name is Steve Burton, and thank you very much.